Good morning, everybody. Thank you for joining us. For those who don't know me, my name is Cheryl Palmer-Hughes and I'm a partner in the Serious Injury Department at Irwin Mitchell, and I specialise in cross-border claims on behalf of people who are seriously injured. I hope you're all well. I hope you're adjusted to your new tier levels today. We've survived another lockdown, and I think it's fair to say that coronavirus has been a little bit like Brexit. We've had a few uncertainties, to say the least. We've not been entirely sure about what's going to happen. And as we come out of one lockdown and hurtle towards Christmas, we can't ignore the fact that we've got a Brexit deadline just beyond that. So we've got a fantastic panel of speakers for you today, and my colleague Jane is going to introduce them for you.
Thank you, Cheryl. My name's Jane Anderson. I'm a practice development lawyer within the Commercial Litigation Department at Irwin Mitchell. Also joining us on today's webinar are Sarah Prager and Connor Kennedy, who are barristers at 1 Chancery Lane, also with specialisms in cross-border jurisdiction issues. I am now going to hand over to Sarah, who's going to discuss what the present position is in respect of such cross-border disputes. Sarah, thank you.
Thanks, Jane. Yeah, I've been asked to give 7 minutes worth of chat on what the current jurisdictional rules are in relation to recast Brussels, in relation to the European position. It's a bit of a big ask, but I will do my best to keep to time. So the current position now, it's really important to bear in mind that after the 31st of December, the current position will change completely. And Connor will talk to us a little bit more about what's going to happen or what we anticipate will happen after that time. But for the time being, the rules, the important thing to remember about the current rules within the EU are that they are completely certain. So the distinction between what the rules are in relation to jurisdiction now with Europe and with the rest of the world countries are in terms of certainty more than anything else. So in relation to claims brought in relation to foreign accidents occurring in, let's say, Tunisia, somewhere outside the EU, we look at forum conveniens and forum non-conveniens arguments in the common law. In relation to European claims, we look at recast Brussels, which gives us total certainty, because under recast Brussels, the general rule is that the defendant has to be sued in the country of their domicile, which provides a really clear and usable rule that everyone knows they need to come within, unless one of the exceptions within recast Brussels applies. And those exceptions relate to, in relation to tortious claims, it's the place of the tort. In relation to contractual claims, it's the place of the contract. In relation to consumer contracts, there are special rules. In relation to employment contracts, there are special rules. And it's all geared towards protecting the weaker party in any bargaining relationship. So it's geared towards, in terms of consumer contracts, it gives the consumer a choice of laws. In relation to employment contracts, it gives the employee a choice of laws, because the entire underpinning behind the recast Brussels regulation is that there should be certainty, but there should also be protection. And the EU is always very keen to protect weaker parties from bullying by stronger parties. And they've just extended that protection to corporations, people like hoteliers, who are entering into contracts with booking platforms. So there's just been a recent decision of the CJEU, which is to do with a hotelier who said that they were in a weaker bargaining position against Booking.com, for example, and the CJEU protected their position and held that they were entitled to bring jurisdiction within their own domicile. So those are the underpinnings: harmonisation, certainty, but protection of weaker parties. And that's really what recast Brussels is all about. That's really why there are exceptions to the general rule that a defendant has to be sued in the courts of their own domicile. What's the effect of that? Well, it means that consumers are protected, people who've been injured in accidents are protected, because they can not just sue defendants in the courts of their own domicile, they can sue defendants in the courts, they can bring them within the jurisdiction of their home jurisdiction, the claimant's home jurisdiction. One of the really big things to come out of recast Brussels is, of course, the Odenbright jurisdiction, which allows claimants to sue insurers directly where there is a direct right of action under the law, either of the insurance contract or where the accident took place, they can sue insurers directly in their home domicile. And that's why we see lots of claims being brought at the moment, foreign accident claims, where someone has gone abroad, suffered a road traffic accident, comes back to England, and then is able to sue within the jurisdiction of England and Wales. And that's really, really important for claimants because, first of all, it enables them to sue more easily. They don't have to go abroad to sue. And secondly, of course, recoverability of costs, because it's much easier to recover costs in English courts, and those costs are much higher than they are in other European nations. So that's a really big jurisdictional boon that arises for claimants, arising out of the operation of the regulation. And of course, that arises not just from Recast Brussels, but it is, as I say, the Odenbright jurisdiction arises from case law of the Court of Justice of the EU. So their decision in Odenbright gave rise to that jurisdiction. Not only that, but their decision in Spedition has led to a situation where the insurer has to have handling agents in all of the nations of the EU, and the claimant can serve their proceedings on those handling agents, which makes it much, much easier, because previously it meant that you could bring proceedings in England and Wales, but you had to sue the defendant insurer and translate those proceedings and then serve them in their home domicile. Now you don't have to do that. So it's very easy for claimants to bring those claims against foreign insurers under the current regime. Of course, Spedition, again, is a decision of the CJEU. That will go when we Brexit. So it's going to mean that there will then be a difference, which Connor will tell us a little more about in a moment. But those are the advantages to claimants of the current situation, of the current rules under Recast Brussels. They're very mechanistic, which means that they're very predictable. It means it's easy for us as lawyers to advise where jurisdiction is likely to end up, because we know that the rules will work in a certain way. And although the Court of Justice of the European Union keeps turning out case law, which then amplifies and explains and clarifies Recast Brussels, they only tend to do that in one direction. They only tend to do that to give weaker parties greater choice than they had before. So we know that the claimant is going to have the opportunity to sue the defendant in the court of the defendant's domicile. We know that they're going to have the opportunity to sue the defendant in the court of the place where the tort occurred. And then the European Court then incrementally increases the jurisdictional choice, so that it means that the claimant then has the opportunity to sue the insurer directly in their home domicile courts. So incrementally, jurisdiction has increased under Recast Brussels, but in quite a controlled way, and always with the underpinning that the Court of Justice is very keen to help the weaker party, or the party that's perceived as being weaker in the relationship. And as I say, incrementally, they're increasing that to include weaker companies as opposed to individuals as well. So quite interesting things going on in the Court of Justice at the moment. We, of course, will not be bound by those going forward unless there is a deal. And Connor's going to tell us a little bit about what he anticipates will happen next.
Thanks, Sarah. Yes, so as Sarah says, the current the current European regime, which covers the Brussels regulation and the Lugano Convention, currently apply automatically. So that makes life extremely simple for claimants and for lawyers. That's all coming to an end on the 31st of December this year. Now, I know that the UK government Lugano, and it has applied to accede to that. It's also applied to accede to the 2005 Hague Convention, which allows parties to essentially agree choice of jurisdiction. Obviously, that's going to be quite helpful for commercial parties who have a contract in place before any sort of claim arises. But if you're talking about the ordinary, sort of travel claim, RTA abroad, obviously the parties aren't going to have a contract in place before that happens. So they would be hoping for accession to Lugano. The difficulty is that even after firstly, all of these sort of European member states need to agree to the UK's accession. And even once that's done, there's a sort of 3-month waiting period. And unless something unforeseen happens, essentially the deadline for that has come and gone in order for that to take place in time for the 1st of January. So unless there's some sort of extremely nimble negotiating by the UK and the European member states, we're going to have at least some period of reverting to the common law rules. So going back to the old common law rules, these are the rules that we apply for claims outside of Europe. Essentially, the English court will have jurisdiction either where proceedings have been served on a defendant, or where alternatively a defendant submits to the jurisdiction. So dealing first with service of a defendant, so long as the defendant is within English jurisdiction, even if temporarily, so even if they're passing through, they can be physically served with proceedings and the court can thereby gain jurisdiction. Now, that's not the end of the story, of course, because the English court can then decline jurisdiction if there is another more appropriate forum, or if the parties have agreed to refer their disputes to the courts of another country, or if, for whatever reason, the proceedings amount to an abusive process. Where a defendant is outside of the jurisdiction, the English court can still exercise jurisdiction, but claimants would first need to seek permission of the court to serve outside of the jurisdiction. So again, that's something that we don't have to do at the moment under the European regime. And of course, the requirements for getting the court's permission are set out in CPR 6, Practice Direction 6A, and there are numerous sort of grounds on which the court can grant permission. General grounds, for example, where someone is domiciled within the jurisdiction, but outside of the jurisdiction at that time. Where there's a claim for an injunction against an act that may be done within the jurisdiction, claims relating to contracts that are made within the jurisdiction or governed by English law, or claims in tort where the damage was sustained within the jurisdiction or as a result of an act within the jurisdiction. And there are other grounds relating to trusts and so on, and property. Alternatively, of course, the defendant can submit to the jurisdiction, which makes things a lot simpler. Defendants need to be very careful on this point because, of course, if they do dispute jurisdiction, they need to do so quickly at the outset under CPR 11. And a defendant can be treated as having accepted the court's jurisdiction if they don't make an application to challenge jurisdiction within 14 days after filing an acknowledgement of service. So it's the kind of thing that an unwary defendant could accidentally submit to English jurisdiction, whereas they could make life a lot more difficult for claimants who, if they simply don't accept that and immediately dispute jurisdiction, and force the claimant to navigate the much more uncertain waters outside of English jurisdiction. So I think just to quickly summarise, the post-Brexit position, there's just a lot of uncertainty because really it depends on what comes out of these negotiations between the UK and the EU, which are going on in secret at the moment, or in some degree of secrecy. But what is clear is that certainly unless the UK secures the Lugano access, there's going to be a lot more discretion, whereas the European regime involves a lot of automatic outcomes. The English sort of common law system involves a lot more discretion. It's going to be more expensive, and there is going to be a lot more uncertainty, and it's going to be slower. It's going to take a lot longer. So it's not ideal for anyone really, but we'll just have to wait and see what happens. Sarah's going to discuss enforcement pre-Brexit now, and then I'll come back to that post-Brexit.
Yeah, thanks, Connor. Yeah, I mean, enforcement, I think, is one of those big areas where it looks as if there's going to be a really, really big difference between what is happening now and what is likely to happen after Brexit. And the reason for that is, again, it's recast Brussels. Enforcement under recast Brussels was intended to be really straightforward, really clear, and with no difficulties at all. And that's the whole idea behind recast Brussels, that there is recognition of judgments between nations in the EU, and that those judgments are then enforced without any kind of difficulty between all of the European nations. And that's what recast Brussels says. And following Brexit, of course, that's going to be removed again, which means that there will then be knock-on effects on how we enforce after Brexit. I actually think that this is one of the situations where there may be less difference than we think, because what's actually happening in practice is not necessarily what was intended under recast Brussels. So the intention under recast Brussels was that it would be much, much easier to enforce British judgments abroad and foreign judgments within the UK. It was intended that there was no need anymore to get double certification and to go through all of the process of going back through the courts. So what happens currently, as you'll know, is that if you get a judgment in the English courts, let's say, then that judgment then becomes automatically recognised under Article 35, I think is one of the 30s, in recast Brussels. It's recognised and therefore it will be enforced within their enforcement mechanism. That's the theory of it. That's how it ought to work. But actually what's happening in practice is that it's not quite working in the way that it's intended. It's not quite working in the way that recast Brussels says it should. So there shouldn't be any reason as to why that doesn't work perfectly well. There shouldn't be any reason as to why you don't just get your English judgment recognised and enforced in the usual way. And so you, let's say you have a judgment against Greek Guarantee Fund, let's say, their version of the MIB. You get your judgment in the courts of England and Wales, you take it to the Greek courts, you ask them to recognise it, they recognise it, and then it is enforceable in the usual way. That's not happening, and it's particularly not happening in Greece, but it's not happening in some other of the European nations as well. So we've seen that there are some of the European nations are very unwilling to enforce particularly cost judgments. And I believe that there is still a case still going through the Greek court system in which the Greek courts are refusing to enforce an English cost judgment. Now that shouldn't be something that happens under recast Brussels. That shouldn't be possible because that's not the intention of the regulation. But it is happening because some of the EU courts find it very difficult to accept that English cost rules are what they are. So in some of the European nations, you don't get anything like the significant cost judgments that we are familiar with in the English courts. And that means that when those judgments go across to Europe for enforcement, it's possible for the party against which enforcement is being sought to then argue that those judgments shouldn't be enforced because they're contrary to public policy. Because recast Brussels contains that exception still, that if the judgment of the foreign courts goes against public policy, it is permissible for the court that's being asked to enforce it not to enforce it. That is intended, I think, to relate to wholly exceptional circumstances in which the judgment of the foreign court has been obtained in some way which is underhand or something of that nature, or there is a very distinct and clear policy clash, which is not the kind of thing we ought to be seeing actually within Europe. That's not the European ideal. That's not what is anticipated and wanted by the EU 27 as they now are. But that is the intention behind that exception, that if there is a public policy problem, that the enforcing court should not enforce it. But what we're actually seeing is some of those foreign courts saying, well, actually, your costs rules are against our public policy, and therefore we will not enforce them. Now, that is an issue that's been ongoing for quite some considerable time. Certainly this Greek case that I'm talking about has been ongoing for quite some considerable time. And there are arguments, therefore, being heard in Greece about whether or not our rules about cost recoverability are against their public policy, with the argument being, by the party against whom it's being sought enforcement, with the argument being that this very significant cost recovery is against public policy. It's something that should not be happening, and therefore it shouldn't be enforced by the Greek courts. And that's therefore something that is causing something of a stir there. And I foresee that after Recast Brussels goes, there is going to be still further arguments of that nature. But I'll hand over to Connor now. I think we're about halfway through, so just thought if there are any questions. We're all giving you what we think is happening, what we think is going to happen. Absolutely delighted to hear from you. I know that we've got a number of people here who are from foreign jurisdictions. We've got some Greek, some Spanish, I think, some Italian lawyers and clients. And it'd be really nice to hear what your experience is of that, whether you've got any insight into those difficulties, enforcement problems that there are, any questions you want to ask us about enforcement, about certainly pre-Brexit and post-Brexit stuff. Yeah, I'll hand over to Connor so he can tell you a little bit about enforcement in what we see as being the post-Brexit world.
Thanks, Sarah. So as Sarah said, the theory is that everything should be very seamless under the European regime in terms of enforcement. It's not necessarily the case, but I think it is costs and certain jurisdictions such as Greece to one side. It is much more seamless than it was formerly to enforce judgments across jurisdictions. As I said, with jurisdiction, with enforcement, we go back to the common law rules. Under the common law rules, the situation is that separate proceedings need to be commenced in order to enforce a foreign judgment in English courts. There are also statutory regimes that can apply in relation to certain countries. So the two statutes you need to be aware of are the Administration of Justice Act 1920 and the Foreign Judgments Reciprocal Enforcement Acts 1933. So they'll cover countries like Australia, Commonwealth countries, but essentially you're just going to have to check those statutes and see if the country you're interested in is on the list. In terms of enforcing judgments from EU courts post-Brexit, judgments from EU member states in proceedings that were commenced before the end of the transition period will continue to be enforceable in the UK under the recast Brussels regulation. In terms of enforcement of English judgments in the EU, from the 1st of January, judgments of UK courts in proceedings that were commenced before the end of the transition period will continue to be enforceable in EU member states under the recast Brussels regulation. But the uncertainty kicks in where you're trying to enforce judgments for proceedings started post-Brexit. And I think we've got a question from Georgios on this, which we'll come to later. But essentially, how and to what extent you can enforce an English judgment in an EU court will be determined very much by the individual law of that member state. So different states have different views on English judgments, and that's going to introduce a lot more uncertainty and costs. And in some cases, parties might find that they can't enforce an English judgment in a member state. Another point I wanted to mention, I think enforcement is the best place for it, is changes to the CPR, a significant change to Part 25, which relates to security for costs. Security cost is currently available where the claimant is resident outside the jurisdiction and outside a state which is a party to essentially to the European regime. Now that's going to change. Part 25 is going to be amended to remove reference to the Brussels Convention, the Lugano Convention, but it's going to keep the reference to the Hague Convention, which is the sort of relevant statute or relevant treaty relating to commercial agreements, really. That gives rise to some uncertainty in terms of the drafting, because of course, if you have for example, a judgment in tort, and then you try to enforce that, or at least, sorry, if you're being sued in tort and you try to get security for costs, and you make the argument that, well, this claimant is not, is not party to a a Lugano Convention state, for example, they might seek to argue that, well, in fact, I'm covered by Part 25 because I'm resident in a Hague Convention state. I think there's probably going to be some litigation on that, and the courts will probably have to clarify whether the security for costs exception applies to people living in Hague Convention states, or only to people in those states so far as their proceedings are covered by the Hague Convention. So that's a bit of uncertainty in relation to Part 25 and security of costs. Apart from that, just you're going to need to rely more on foreign lawyers, essentially to ask them whether in Greece, in France, in whatever state, what the view of the courts in that country are towards English judgments. That's enforcement post Brexit, as far as I can tell. As I say, there's going to be a degree of uncertainty. It might be that those statutes that I've mentioned are amended or updated to deal with further individual agreements with the EU member states. It's just essentially, as with jurisdiction, it's going to make things slower, more expensive, and less certain. So that's enforcement post-Brexit. I think I'm handing over now to Cheryl. Is that right?
That's right. Thank you, Connor, and thank you both. It was a huge ask to ask you to take us through something that personally took me a few years to get to grips with, and we've done it in just over 20 minutes or so. So thank you for so skillfully taking us through the key principles of the regime as it is now. We have had a couple of questions, so thank you so much. And if you do have more, keep them coming. We have allowed the last 15 minutes or so of this slot for us to go through your questions. We'll do our best to go through all of them. If there are any that we need to pick up afterwards, then we'll get in touch with you separately as well. So we've had a look at what the regime is now, and the sort of legal principles behind how we establish jurisdiction, what we do about enforcement, and what that might look like post-Brexit. And we thought it'd be interesting to have a discussion about actually practically how does that affect our clients. So as you on the webinar, how might it affect you? How might it affect your business? I'll speak to you briefly about how it might affect personal injury clients, and Jane will speak to you from a more commercial side. But before we get to if there is a claim, where we bring it, and hopefully we get a judgment on how we enforce it, there are a couple of points that we won't have time to explore in full today, but they're important practical points. Looking ahead in terms of protecting ourselves in the event of something going wrong, or there being a dispute. There is already a lot of reliance on the European regulations, which are inherently protective of consumers in allowing them, for example, to bring their claim in their home court. And one of the biggest advantages, alongside overcoming issues of translation, dealing with a foreign court system, for people who are bringing claims in England and Wales, one of the biggest benefits is being able to pursue those claims on a no-win, no-fee basis. Often the cost of litigation is high, and it is very rare that somebody would be willing to finance that out of their own pocket. So that's one of the sort of practical points in terms of looking at bringing a claim over here. And then both Sarah and Connor have referred to stages in the litigation that actually would be more expensive. So even if we can establish jurisdiction over here, and there will be various ways, the challenges that we might face, and we face them under the current Brussels regime, the challenges that we might face mean that there will be more preliminary issues hearings, perhaps more challenges, all of that increased costs for those who are pursuing claims through the civil courts. And that's an important consideration. How is that going to be funded for people who are going on holiday, which is a lot of our clients? Have they got sufficient travel insurance? Have they got something in place in the event that proceedings are brought over here and they're very costly? Or the alternative, and this is the position that we're hoping won't arise, is that if it's a bit of a free-for-all, if we don't have a certain regime, if we're dependent on separate agreements or different conventions country by country, in a lot of jurisdictions around the world there aren't the sort of no-win, no-fee provisions for people bringing claims. And so how will those claims be funded? A lot of them in other countries ask that fees be paid up front and privately, come what may, with very little scope to get the full cost of those legal expenses reimbursed by the losing party. And so it's really important that on a practical level, we hope that people don't find themselves in this situation, but if they do, it's a very different landscape to the one that we're in now, where the sort of fallback and assumption, certainly for consumers travelling from England to European countries, is that they might be able to pursue their claim on a no-win, no-fee basis. And all of this comes back to the initial point that Sarah was talking about uncertainty. And I think it's important that people realise that if they are holidaying within Europe, yes, it will be perhaps more difficult. We don't know exactly what the rules will be for travel. But yeah, if something goes wrong, in the absence of some form of agreement, joining the Lugano Convention, there'll be huge uncertainty as to actually what the state of play is and what the route to justice is. And that is difficult to manage, but also I think the important point there is it's very costly. And no matter what route we take, if there is not a set agreement, if we're not party to Lugano or another convention, then there are likely to be challenges either way. If we're trying to bring a claim in England, that then I anticipate there will be challenges made by defendants to that. Likewise, if we're in a different country, there might be challenges to that as well. So it's an uncertain picture. It's not completely bleak, because those of us who work in this area, you know, we're very passionate about the academic side of it, and there are various ways that we will be able to support clients with their disputes. But I think it's important to realise that actually we're potentially facing a period of uncertainty. And does that apply for your clients as well, Jane?
Thank you, Cheryl. Yeah, I think the overwhelming word to take away from all of this is uncertain, and it's exactly the same for commercial clients as it is for those clients pursuing personal injury claims, really. Connor has already gone through the points on enforcements of judgment, because a lot of concern is going to be around court cases which have concluded, judgments have been handed down, and this is going to continue up until the end of the implementation period, and when we exit on the 31st of December this year. But what can you do with those judgments? Are you going to be able to enforce them? Will EU member states recognise those judgments and seek to assist you? And at the moment, the answer is we just don't know, because we don't know what convention is going to apply at the end of the implementation period. And so much of this is up in the air. From the point of view of claims themselves and your choice of law and your choice of court, it's slightly easier for commercial clients, because in most cases you will have a contract, and that contract will state your exclusive jurisdiction clause and your exclusive choice of law clause. And the position in that respect is that the UK courts are going to continue in the same vein that they have done currently under the current regulations, and English courts are going to respect those choice of law clauses. Whether the same is said for the remaining EU member states, unfortunately we just don't know. The starting point in relation to judgments is going to be your favoured court, and then what you will need to consider is whether you are likely to need to enforce that judgment in another EU state. That's not going to necessarily be the case for all cross-border disputes, because you might be in a position where your opponent has assets in the territory of your choice, or your opponent is going to be unable to ignore the judgment for reasons such as regulatory or reputational ones. In a no-deal scenario, the current regime will in the main be repealed, and that includes the rules which decide where a case should be heard where there are cross-border issues between the UK and other EU countries. So what's going to apply is the domestic rules which the UK currently applies to non-EU countries. So litigants are going to have to consider how those rules, the UK rules, interact with the rules of the relevant EU countries to understand how jurisdictional issues in cross-border disputes are likely to be resolved. Unfortunately, the interaction between those rules may not be clear, and as we've already said, judgments from UK courts may not even be recognised by other EU courts. It's much simpler if the UK is readmitted to the Lugano Convention, because actually what that's going to mean is very few significant changes to cross-border litigation between the UK and the other Lugano signatories, which are Norway, Switzerland, Iceland, and then the remaining 27 EU states. If the UK was readmitted to the Lugano Convention, what that's going to mean is that UK courts would continue to recognise and enforce judgments of other contracting states and vice versa. However, readmission to Lugano is currently being blocked, and I'm going to hand you back to Cheryl, who's going to talk us through that point further. Thank you, Cheryl.
Thanks, Jane. So I just had to Google actually just to check that it was 4.5 years ago that our country decided to leave Europe, and since that point, as a firm, certainly within our department, we have been concerned about protecting the rights of our clients beyond Brexit, and obviously there've been various discussions about deals in different guises, and I know that through joining meetings with the Law Society, they have a private international law working group, and I sit on that group, and there has been concern that perhaps the benefits to individuals and smaller businesses have been perhaps overlooked or underestimated by our EU member states. What I mean by that is that it's not just a one-way street. We obviously look at this through the lens of representing predominantly people who are domiciled in England and Wales, but actually there are benefits both ways. And so we have adopted, as part of that group, a variety of channels of communication with leading parties in member states, and we were doing that sort of on an ad hoc basis based on the contacts that we had. And just last week, the Law Societies of England, Wales, Scotland and Northern Ireland, backed by a number of English entities, have written to the President of the European Council and other leading parties in Brussels, urging them to agree to us joining Lugano Convention once we have left, once we're at the end of the transition period at the end of this year. So hope isn't lost. I know there's a flurry of optimism when UK Parliament actually sort of put in that request, and it has been quite frustrating that the member states have not agreed to that, and we're hoping that these communications and explanations as to why we think it's beneficial on a mutual basis, not just to England and Wales and the rest of the UK, we hope that that will be heard. Obviously it's difficult times. Pandemic has, I hope, explains why we're at the beginning of December and we still don't know what's going to happen. The reality is, at this point, everybody seems to agree that Lugano would take around 3 months to get everything sorted and for us to be party to it. And so there is best case scenario, if the other member states accept that we join Lugano, there will be a period of perhaps 2, possibly even 3 months, or even beyond, because there's nothing stopping us beyond January to continue these discussions, where we won't have the benefit of the Brussels regime that we've explored already, nor will be party to Lugano. So we might have 2 or 3 months where we're under a no deal scenario and regime. And so what the Law Society is doing helpfully in the background is preparing for that contingency, preparing and liaising with Ministry of Justice and the government to see how we might prepare ourselves and what sorts of transitional provisions we might need during the time, if it is that, you know, as soon as the member states say yes, we agree for you to join, because it has to be unanimous in terms of us joining, then we will have some provisions in place. And some of the practical steps that we've taken on behalf of our clients to protect them the best we can, and the best we can is to advise them as to what we know the case is now before the end of this year. So that's probably issuing proceedings, establishing jurisdiction over here. There shouldn't be, from our point of view, too many clients who might be caught in that period in the new year, but there are obviously concerns for people who might have limitation periods coming up in those months if they do transpire, who might have to issue and commence proceedings in a bit of a vague different regime if we're working towards joining Lugano. But I mean, I think the consensus on this talk certainly is that the benefits of us joining Lugano are huge, and I know that we have explored those in the discussions that we've had previously. But from your point of view, Sarah, what are the overriding benefits of us switching to Lugano, even if it means we have this messy 2 or 3 month period first?
I think it's certainty, isn't it? I mean, I think the whole point about Recast Brussels is that it gives certainty, and the whole problem with what we're now facing is that it brings this enormous uncertainty. And I think the whole, whether you think Brexit was a good idea or a bad idea in the first place, the issue with Brexit has been the last, I can't believe it's 4.5 years, but that really quite big chunk of time where nobody had the faintest idea what was going on or what was going to happen. And we're now less than a month away and we still don't know what's going on or what's going to happen. And we're beyond the point of no return with Lugano, because as you say, it's going to take 3 months from everyone agreeing to us actually being able to accede. One of the issues with Lugano as well, don't forget, is that some nations can derogate from it. So even if we enter into Lugano, it's still theoretically possible that some of the less cooperative European nations will say, well, I don't want this applying to me. So it will apply to the rest of Europe, but not to them. And that's going to give rise to a real issue. So I think the good thing about Lugano is going to be that it's going to bring a degree of certainty and stability. The problem with Lugano is that we're going to have this 3 month, more than 6 month period, however long it is, where we actually don't know what the rules should be, and we have to fall back on the common law rules that Connor's been talking about. So we know that we've got certainty between now and the end of the year. That's the only thing we can be really certain about, and that's why everyone is rushing to issue proceedings, because it's much better for lawyers to issue under a certain regime, because those proceedings will certainly lead to the courts of England and Wales having jurisdiction, and they will be enforceable. After that time, it's anyone's guess between December and whenever Lugano kicks in. So there's going to be this gap in time. The other thing about Lugano is, don't forget, it's not exactly the same as Recast Brussels. So those of us who were around before Recast Brussels, we remember Brussels. Lugano is much more similar to the Brussels 1 regulation than it is to Recast Brussels. And by that I mean that Brussels 1 wasn't completely satisfactory, that's why it was recast. Lugano maintains those unsatisfactory elements. So things like choice of law clauses are weaker under Lugano, so they're not the complete answer under the Lugano Convention. Things like concurrent parallel proceedings, what was known as the Italian torpedo was something that was really prevalent under Lugano. It can't really happen under Recast Brussels. If we go to Lugano instead of Recast Brussels, the Italian torpedo is going to come back. And by that, I mean that if a defendant wants to deprive a particular claimant of jurisdiction, all they do is they issue first in their home court for a declaration as regards the amount that they would owe the claimant if proceedings were brought. So the Italian torpedo is a really big issue with Lugano, and issues of lease alibi pendens, which were sort of ironed out in Recast Brussels, still maintained in Lugano. So that is a potential problem. Recast Brussels also led to what we would call, in common law terms, an exorbitant jurisdiction. So it led to jurisdiction with defendants who are domiciled outside the EU, where there was a foreign element, where the claimant was domiciled within the EU. Lugano doesn't do that. So Lugano is slightly less certain than Recast Brussels. It's possible to derogate from it, and there are issues and tensions there, which is why we recast the regulation in the first place. So it's Lugano we are all viewing as being the great hope, and it is the great hope because it gives rise to more certainty than nothing. It's still not perfect. Now, of course, what we will have if we don't have Lugano is going to be the Hague Conventions, and I understand that there's a whole suite of conventions, and that may be something else that we might cling on to. And I think, Connor, that's your particular topic. an area of expertise in this.
Yeah, thanks, Sarah. So I've been asked to discuss briefly the impact of the Hague Convention. So the Hague Convention is great for commercial parties with a contract in place which contains an exclusive choice of court clause. It provides that judgments given by courts that are so designated to be recognised and enforceable in other contracting states. The EU acceded to the 2005 Hague Convention in 2015. The UK has now essentially it's deposited, I think it's called the Instrument of Accession on the 28th of September of this year. That ensures that the Hague Convention will continue to apply seamlessly from the 1st of January. So unlike the Lugano Convention, where Sarah's mentioned that 3-month gap, with Hague it's just going to be seamless. So that's great. There is, however, an issue in that, I mean, there's an issue with the material scope of what is an exclusive choice of court agreement, but that doesn't really relate to Brexit. That's already an issue. But the second issue that can arise with choice of court agreements in under the Hague Convention is about the temporal scope of the Hague Convention. So obviously the European Union, as I say, acceded on the I think it was October 2015. The question is whether there's a infinitesimally small gap between the 31st of December this year and the 1st of January 2021, so that the well, the reason this is significant is because the Hague Convention only applies to exclusive choice of courts agreement concluded after its entry into force in the state of the chosen court. So there's some danger that it would only apply to agreements entered after the 1st of January 2021. Both the EU and the MOJ have issued notices or guidance in the MOJ case about this. The EU's notice states that the convention will only apply between the EU and the UK to exclusive choice of court agreements concluded after the convention enters into force in the UK on the 1st of January 2021. Really, the MOJ guidance, on the other hand, says no, it will apply to agreements concluded from the 1st of October 2015. So as I say, there's some uncertainty there about whether there might be a gap in that respect under the Hague Convention. Most UK commentators seem to think that that English courts will view this as will view the convention as coming into force in the UK in 2015, so there shouldn't be any issues there. And it seems to me that is the sort of sensible analysis of the Hague Convention's application in the UK. So I think we're on to Q&As now. Is that right?
Yes, that is. Thank you, Connor. So the first question that we've got, please do continue to put questions in the questions and answer box on your screen as we're able to take questions. We've got another 12 minutes or so to be able to do that. The first question is for Sarah, actually. How does a contractual position impact the enforceability of judgments, and can the contractual position be overridden?
Okay, I could give you an hour on that, I think, but I'll try and keep it to a couple of minutes. Okay, thinking it through, let's say there is currently, you've got an exclusive choice of law or choice of jurisdiction clause, then that works under recast Brussels. Under Lugano, it doesn't work as well. If it's a contractual dispute and it's not a PI dispute under the Hague Convention, it works. In relation to enforcement, I'm not quite sure what the question is asking, because in relation to enforcement, you need a judgment in order to enforce. So you'll have got past looking at the contractual choices position. So contractual choices only work for, let's say, applicable law or in relation to jurisdiction. I suppose choice of law or choice of jurisdiction clauses are given varying effect by varying nations. I realise that's not a terribly helpful answer. That's a barrister's answer, which is, you know, I can give you the English position, which is what I am doing, but you may find that in the foreign courts that their less choice of law or choice of jurisdiction clauses are less important than they are in England, certainly under the common law rules. So once we leave, so in January, between January and Lugano, any choice of jurisdictional choice of law clauses are going to be important, but they're not that important. They're not as important as you would expect. So if there's a contract that's got an exclusive choice of jurisdiction clause which gives English courts jurisdiction, the English courts may give effect to it, but won't necessarily. So that's it is a gateway. So you get through the jurisdictional gateway because you've got a choice of jurisdiction clause, but you don't necessarily get the English courts taking jurisdiction. So they're not. They become less important is the short answer. Sorry, I should have said that in the first place.
Thank you, Sarah. The next question is from George, and I think Connor already alluded to this question earlier. So it's a scenario question. I think probably Cheryl is where we'll start to answer this question. So I'll just read out the scenario. We have an English driver and an English passenger who are both domiciled. Now, George has suggested in Preston, but they're in Tier 3 at the moment, so they're not going to be doing this for some while. Both are on holiday in Zante, and the driver rents a Greek registered bike insured by a Greek insurer. He crashes into a tree and his passenger is paralysed. So the passenger can of course sue in Greece and wait 10 years to get compensated. But can she bring proceedings against the driver before the English court? So Cheryl, can I hand over to you?
You absolutely can, and thank you for this question, George. I mean, it's quite a simple answer to that bit of the question. Yes, because both driver, well, defendant and claimant live over here, then there's no question, regardless of what happens after the end of this month, as to their ability to bring a claim in the courts in England. And I know that George, you've added to it because it's a very practical question. So moving on to the second bit. If it is the case that the driver can, that the injured party can bring a claim against the driver before the English courts, can the claimant also join the Greek insurer to the proceedings? And if not, or sort of as an aside point, who is actually going to pay any compensation, any judgment for compensation? I think that's the important point with this scenario. And please do correct me if I'm wrong, George, in terms of looking into the future. My first comment on this, it goes back to the practical issues that I was introducing earlier. In terms of people who are going abroad, you know, let me use this as an opportunity. I will never waste such an opportunity to ask that people look at their travel insurance documents, look at the insurance documents that you're signing when you are going out on a quad bike. It's unfortunately quite a common scenario where people are injured on quad bikes on holiday for a number of reasons that I won't explore today. But it's crucial because, yes, in practical terms, we could bring a claim against the driver in England, and that sort of establishing jurisdiction here is quite simple. But that person who's driving this bike or the quad bike, are they actually able to satisfy any judgment for compensation? And this is why we do often look to see whether we can bring an insurer into the proceedings. And what do you think about that, Sarah, in terms of bringing a claim against the driver and then seeking to join the insurer, thinking in the scenario of it being a post-Brexit world?
I think, again, I'm going to say it depends. You know, I'm not going to make myself any more popular here than I was before. The English courts will take jurisdiction where you have an English anchor defendant. So that's one of the jurisdictional gateways. So if you can get through that gateway, so there's one anchor defendant who is domiciled in England, then they can anchor defendants from all over the world, if England is the appropriate forum for that. And usually the English courts will say, well, it is the appropriate forum because otherwise there's a danger of parallel proceedings, a danger of irreconcilable judgments. So I think the jurisdiction is possible against the insurer. I'm just trying to think that through as to how that would work. but you would have to serve the insurer in their home domicile, and you would have to translate proceedings, and you would have to go through the foreign process section, so you couldn't serve on a handling agent. So I think there would be disadvantages. So essentially, I think the message is really that Brexit brings disadvantages to, first of all, to people who want to bring claims, and secondly, to people who defend claims, because there is lack of certainty there. And actually, I'm doing a jurisdictional challenge next week, which relates to rest of world. And this is a jurisdictional challenge that's been going on. I know COVID's going on, but it's been going on for a year. So it's going to, this satellite litigation is going to disadvantage everybody else, because all the other parties in that litigation are waiting for the outcome of that jurisdictional challenge, and they have been for a year. So it does have actual, real, practical knock-on effects on people who may or may not be entitled to damages, but people who ought to have an expectation that they can have their claim dealt with properly. So I think it is a real issue, and I think actually the answer to George's question is that anyone travelling abroad, as Cheryl says, ought to be getting insurance, because it's so much easier to get an insurance payout in this country from an English insurer, either voluntarily or you can force them to do it within this jurisdiction, because you can see them in this jurisdiction. So if there is any element to your life that involves being abroad, or any foreign elements, insuring against it is the answer for the moment. And I appreciate that that's not very helpful coming from a lawyer, but I think that is the practical advice to give people.
Thank you, Sarah. We've got one final question, which I'm going to pose to Connor. And it's more a discussion point, really, rather than a question, Connor. And it's just about the UK's position as the court of choice for cross-border litigation, and whether we consider, or you consider, whether that will remain the case in a post-Brexit world.
That's a good question. I think, I think the advantage in choice of law clause, you're going to be talking about commercial parties. The advantage of English law is that it is so well developed, and there's so much certainty there for commercial parties. I think there seems to be a sort of growing interest in having commercial contracts governed by New York law. I think probably what it comes down to is who the lawyers are drafting these agreements, and whether they're New York lawyers or English lawyers, in which case, they'll invariably choose their own sort of applicable law and jurisdiction. I think that's I think it will still. I think certainly England and Wales will continue to sort of be a choice for jurisdiction and applicable law, just because it's so well established. In the long term, who knows how these things can develop. But I don't think anything's going to change overnight just because of Brexit. In fact, it might make our legal services cheaper to international parties. So I don't see anything changing overnight.
Brilliant. Thank you, Connor, and thank you, Sarah, for your responses as well. And thank you, everyone who has submitted questions. I hope that has been helpful to you. We have gone through a lot of quite technical topics, and so if we haven't had a chance to answer any questions that have been submitted, or if you do want to ask any particular points of us, you should have all of our email addresses on the slide here for you to follow up. And we're all quite visible on Twitter and LinkedIn as well, should you want to communicate with us that way. So please do feel free if you've got queries. I think every single one of us could probably sit and talk about this topic for at least a day, but we were limited to an hour today, so I hope that you found that useful. We do have a series of these events, and obviously they will carry on into the new year, and maybe next time we join you, we'll be able to tell you with certainty what the regime is and what we think that looks like and how that will impact our clients. That's got to be the hope, that we do actually know what the regime is. In the meantime, our next event is in a couple of weeks. It's the same time, so it's a Wednesday at 10 o'clock, and you've got the details up on the screen there, and you'll be able to sign up on a link similar to the one that you used for this, or you can go to our website We have a Brexit Hub, so we keep that updated with industry knowledge, updates about what is happening in terms of Brexit. There'll be something on there probably later today in terms of the Law Society's letter about Lugano Convention, so it's a really useful resource if you want to have an exploration of that. But as I say, please do feel free to contact us directly if you've got any questions, and we will absolutely come back to you separately. But in the meantime, thank you very much for joining us. Enjoy the rest of your day, and we hopefully see you soon.